Good afternoon, everyone. My name is Michelle Fisher, and I'm an attorney with AppalReD Legal Aid. I've worked with AppalReD for about 4 years. It'll be 4 years on November the 14th. And I work particularly with survivors of domestic violence and sexual assault. My coworkers here are going to talk about a couple of other very specific topics as well. As a quick reminder, any comments are public. So if you need them to be deleted for your safety, for your privacy, just make sure you put a P with that, and we will take care of it following the stream. So please just keep that in mind as we go forward. In terms of services and things that we offer and that I deal with. So I deal a lot with family law, and that includes protective orders, cases of custody, and divorces. So just some general information about those things. Yes, the courts are open right now. You can absolutely file for a protective order, and you can file if something has been violated as well. So in terms of what that means and what that process is like, you can go to the courthouse and file for the protective order, or do that through the sheriff's office. You can also do the same if there is something that's been violated within your order. I do encourage you to reach out to perhaps us or a court advocate with Bethany House or Adonta Sexual Assault Resource Center beforehand if possible, because we do this all the time and it can be really helpful to just go over what needs to be in your petition. Okay? So I encourage you to do that. You're absolutely welcome to reach out to us, and there's a variety of ways to do that. In terms of getting in touch with me personally, we've got a side door intake process through our legal assistance to victims partners, which are Bethany House and Adonta. We can also do just over the phone intake. You can call our central intake line. You can do an online application. Once upon a time, we did walk-in appointments, and now we're adjusting as we adjust with the times in an effort to keep ourselves and you all as protected as possible. So now we do require appointments rather than just walk-ins. But we're trying as much as possible to keep our services as accessible as possible. So in the course of my grant, I can also assist with expungements, debt collectors, evictions, bankruptcies potentially, public benefit issues, employment issues, tax issues, but these are not things I would consider myself an expert in any of. For that, I do have the benefit of some wonderful, knowledgeable coworkers, and I like to bring them along with me. So you'll get to actually see that today. And I'm very excited to hear what Jimmy and Jake have to share with you all. In terms of other things to keep in mind, we've got lots of different options. If you speak a different language, just keep that in mind. We will accommodate you, and we're here for you. That's what we're here to do. If you need to file a divorce, you can still do that now. If you need to file a custody case, you can still do that now. And we're adjusting as things are adjusting. So it looks a little different, but I like to think the quality of service is still the same. In fact, I know it's still the same because I know this is where our heart is, and we are so excited to share this with you. And I've said it before in the broadcast for Chillin' and Proud, but happy Pride Month. Jake or Jimmy, I'll pass it to you.
Yeah, I can go ahead. And I, as all of us do, we handle various areas of law, but I'm here to talk to you today about two that I'm really excited to talk to you all about because we'd love to see more cases in these areas. And the first one is education. And so a lot of people don't realize that we do help with education cases, education law. And what we do in those cases, it really boils down to access to education. Every child, and so whether you're a student or you're a parent of a child, every child is entitled to what we call in America free, appropriate public education. FAPE is the acronym they use there. And that can look a lot of different, denial of that can look a lot of different ways. So what we see, and we help the most with our special education, cases. So if you have a child who you believe needs some type of accommodation made, whether it's in the classroom or to be able to have, they've got lots of doctor's appointments, need extra absences they should have, or need to take medications at certain times of the day, or any other accommodation that should be made. Those will sometimes fall under what's called a 504 plan, the medical accommodations. And then there's also something known as an IEP, an individualized education plan. That's more of the classroom accommodations. But both of those are out there and available. And if you think your child needs it, your children should at least be getting evaluated for those anytime you request it. And so we know that's not happening all the time. It's just not. And so if you're someone who is maybe having that issue and you're having trouble getting the school to work with you on that, or you just don't know how to ask, we are here to help with that. We also help with school discipline cases. So if you have a situation where yourself or a child of yours is facing suspension or expulsion, they may have legal rights that you're not aware of, and we can help with those types of cases. And then another area that I know we were specifically kind of asked about beforehand that would be pertaining to the LGBT plus community is bullying. That can be tricky sometimes, but definitely if the child is being bullied to the point and the school's not doing things about it, and it's to the point where it's causing them to be denied that right to education that they have, talk to us. We'll see what there is to do. If it's not something we've dealt with before, we'll look into it and see if it's something we can help with. And if it's not, we'll refer you in the direction of someone that might be able to help you. So we'd be happy to see more education cases. Basically, any type of denial of the education that you feel like your child deserves, let us know, and we would be happy to talk to you and see if there's something we can do to help you out. The next topic that I want to talk about is something that I'm really passionate about, because I worked in criminal defense for a while before coming to AppalReD with the Public Defender's Office, and that is the issue of criminal record expungements. And so another thing that we do that a lot of people may not be aware of is we can help you if you have a criminal history, some things on your criminal record from the past. We can actually help you erase that criminal record. So first of all, what is expungement? It's exactly what I just said. It's the erasure of the criminal record. And why do you want to have that done? If you're someone who needs to have it done, I'm sure you know why. It's a great thing to have done. Your criminal record could be keeping you from getting jobs. It could be keeping you from getting access to public housing. It could be keeping you from having access to certain student loans or other type of loans. It could be keeping you from volunteering at school with your kids to go on field trips with them or help out with things at school. And then just the basic dignity of having those criminal records off your criminal record out of your history, because you're more than whatever that happened, some years ago. And so we can help with expungements of almost any misdemeanor crime. Some felony charges can also be expunged, and they've been expanding that lately. So there's more felonies than what used to be eligible for an expungement. And that can take you, if you have the one felony, it can take you from being a convicted felon to not being a convicted felon, and that's a powerful thing. We can also help with dismissed cases. You may not think those are even on your record anymore if it was dismissed, but they are. They show up as dismissed, and it's still something an employer can see when they do a background check, so we can help out with that. Since I'm here, I would also like to plug, and there's information for this on our Facebook page. Something else I'm involved with is we partner with Goodwill. There's an Expungement Clinic coming up on July the 16th. It's a virtual clinic. If you sign up for that, you'll get a lot more information on expungements, and also they will help, if you participate in that, they can help with some of the fees and things like that that are associated with those. And like Michelle was talking about the side door intakes, I don't know if there's a way we can put up my email address or something like that. I don't know how to if I can do that here, but if it's a question where you're not sure and you're just scared about calling the central intake line, we want to be as accessible as possible. We may end up directing you to that central intake line, but if it's a question pertaining to one of those two issues I just talked about, feel free to shoot me an email. Thank you. And that's all I have on these for now, so we'll move to Jim.
All right. I'm James Farringer, and I'm an attorney for the past 2 years with AppalReD Legal Aid in our Somerset office. I think the other two have described this a bit, but I just want to make sure we're, as specific as we can be on this. AppalReD is a free legal aid organization for poor people, other people who qualify, and we serve 37 counties in eastern and south central Kentucky. Our Somerset office serves Monroe, Cumberland, Adair, Russell, Clinton, Casey, Lincoln, Rockcastle, Pulaski, Wayne, and McCreary counties. We do have several other offices. Like I said, it's 37 counties overall in the area. And if you have any kind of legal problem and you think you might qualify, it's worth giving our central intake line a call, because a lot more people tend to qualify for our services than actually realize it. And if you don't qualify, they can let you know that you don't qualify, and you'll have to hire a private attorney. But there's a chance that we might be able to help you. But you have to take that first step to either call our central intake line, or there's an online application process as well. And during non-coronavirus times, we take walk-ins to each of our offices. But like Michelle said, not for the time being, not right now. My main practice area is housing. I represent tenants in evictions, or if they're having other problems with their landlords. I assist homeowners facing foreclosure, and I can also help people who are having problems with, like, a home contractor or something. As far as substantive things that I think are the most important for everybody to know about this area of law, the first thing you need to know is that if you don't pay your rent, your landlord will almost certainly be able to evict you. When your landlord tries to evict you, they have to do it through a court process. They can't just they can't do other things to try to kick you out. So they can't do things like cutting off your utilities or locking the doors on you. Those things are considered illegal evictions if your landlord does them. Now, your utility company, if you're not paying your utilities, they can shut off your utilities. There's a specific process for that. I should also let you know that I also help with issues you might be having with your utility company. But there's a specific process that your utility company would go through to shut off your utilities in terms of sending you a letter threatening to shut it off and that sort of thing. But your landlord can't do it, and your landlord can't just lock you out. They have to go through the eviction process in court. And when you go to court, when your landlord goes to court for an eviction, you have a right to appear at that hearing and to present any defenses that you might have to an eviction. And the reason why I tell you you've got to pay rent or your landlord will almost certainly be able to evict you is that there are very few defenses to an eviction if you haven't paid rent, and the defenses that do exist are almost entirely what we call a procedural defense. A procedural defense is the sort of defense that only kind of delays things. An example of it is that your landlord will probably have to, in order to evict you, will probably have to give you a certain kind of written notice. And if they don't give you that notice, they're not supposed to be able to evict you. So if you go to court and present that information to the court, and the court agrees with you, the court can temporarily dismiss the eviction case. But like I said, it's only temporary. All it means is that your landlord just has to start the process over. And generally, just about any defense you might have, if you haven't paid rent, it's going to be procedural, and it's only going to delay things and make your landlord start the process over. But they will be able to evict you. For mortgages, there are more options for catching up if you're behind on payments. Again, ultimately, if you don't make your mortgage payments, your mortgage lender is going to be able to foreclose on you. But there are some more options in terms of helping you to catch up. And just as an example of something that was true even before before the coronavirus times, your mortgage lender the vast majority of mortgage lenders are required to engage in what's called loss mitigation, which means that they have to do certain things to try to work with you to help you catch up on your mortgage. And they can only start foreclosing on you once you're so far, even a month behind. They can't immediately foreclose on you. They usually have to wait a few months before they're entitled to file the foreclosure case. They can do some other things to start the foreclosure process, like sending you a warning letter which is part of the foreclosure process. But even if you're a few months behind, a lot of them are required by they have certain insurance companies, usually backed by the federal government, that they work with in case you don't make your payments, and they're often required by that insurance to work with you to a very significant extent to help you catch up on your payments. Since the pandemic started, Congress has passed, and there have also been some federal regulations under what's called the CARES Act that can allow you to have a 180-day moratorium on your mortgage payments, and then that can be extended for another 180 days. Now, your reason for not being able to pay your mortgage has to be directly related to the pandemic, but that more things can be included in that than what you might assume, because an example of it could be just that the economy has gotten really bad because of the pandemic, and you can't find a job, and limited opportunities for even during other times when the economy was bad, you could go anywhere and you could apply somewhere. I don't even think that's really entirely true right now. So if there's anything related to the pandemic that's giving you trouble paying your mortgage payment, it's worth trying to see if you can get that CARES Act forbearance. Like your rent, you are going to have to pay it back, and if you don't pay it back, your mortgage lender is going to be able to foreclose on you. But unlike your rent, there can be more opportunities to do that over a period of time, like 12 months or something, rather than needing to do it immediately. Another thing that you should know about the situation right now is that most foreclosures and evictions are on hold because of an order from the government and recently passed laws and regulations at a federal level. But it is important to remember that you still have to pay your rent or your mortgage. Right now, the situation is just that temporarily, your landlord or your mortgage lender might not have their typical remedy for non-payment. But if you're not paying, they will at some point be able to evict you. And this is part of why we say that it's so important to pay your rent if you can. If you don't, your landlord will almost certainly be able to evict you. I also wanted to mention that in theory, I also help with unemployment insurance benefits, but we actually haven't seen any of those cases in a while. And obviously that's a little weird given the current situation, because there are a lot of people who are unemployed and who need unemployment benefits. So if you're being denied unemployment benefits, you have a right to appeal, and AppalReD can help with that. So that's another thing that you want to call our central intake line or apply online for our services if you're having trouble with that. And particularly with unemployment insurance, the vast majority of people who need unemployment insurance benefits and they're being denied it would probably qualify for us on an income basis, because being unemployed means that you're not getting income right now typically. So I'm just not exactly sure what even the reason is that we're not getting those cases right now. But if you're having a problem with that, we would like you to call. And that's all I have.
It looks like we've actually got our first question here about needing assistance with free divorce, and it's particular to Virginia. So the really fun and sometimes frustrating thing about family law is these things are very fact specific, and of course the law is also state specific. So in terms of any advice we could give regarding divorce in Virginia, we can't really, because to my knowledge, none of us are admitted to practice in Virginia. So with that being said, if you contact our office, I am confident we will try our best to help you get in touch with the legal aid program in Virginia. If I get a call from someone in Lexington who needs help with a protective order, I'm going to refer them to legal aid at the Bluegrass. If I get a call from someone out in Bowling Green, I'm going to refer them to Kentucky Legal Aid. If I get a call from someone in Louisville, I'm going to say, check out Legal Aid Society of Louisville. And when possible, I'm going to try to make that personal connection with someone there to make sure that person gets help. Okay. I may try to give some general advice too, just to kind of start with. But as far as Virginia, unfortunately, we don't practice there. I can tell you in terms of what free divorce means here in Kentucky, particularly in our office at AppalReD, there are no fees for our services, but to file a divorce, there may be a filing fee, but you can petition to file in forma pauperis. So what that means is you have to demonstrate to the court you're not able to pay your fees without depriving yourself or your family of food or shelter or some basic living necessities, essentially. And again, this is for the state of Kentucky. And then in terms of other expenses that may come up in a divorce, sometimes there are fees associated. If we can't get someone served, we may need to ask for a warning order attorney to be appointed. And in terms of cost for that, it varies. It can be $250, it can be $500. We're hoping to get something going with maybe some partnerships. We can have kind of a set fee, especially for our clients, but that's not something in the works now. There are also fees for guardian ad litems. Those are folks you can ask to be appointed to assist in kind of custody determination, talk to the kids, see what's going on. That's another fee. There may be fees to use the sheriff to serve someone. So that's kind of a general idea of fees you may still be looking at within a divorce. If you're in a county that does not have a family court judge and they do have a domestic relations commissioner, that person is going to have their own fees. And unfortunately, even if we get someone who is extremely impoverished, often they are still ordered to pay half of that fee. And for that matter, there's also fees in mediation with divorce, which if you are a victim of domestic violence, you cannot just be ordered to mediate with the person who's been your abuser, at the least if you've got a domestic violence order. Now, you may agree to mediate, and sometimes there are good reasons to do that. Like I said, things are very, very fact specific, but I just want to make sure everyone knows what's going on with that. And I just want to clarify too, I mentioned protective orders earlier. To circle back around and kind of in the same thread as divorces, a lot of times private attorneys may approach, and if you're going through the protective order process, may ask you to agree to entry of a civil restraining order. I just want to make sure we say on here there are very important differences between a civil restraining order and a domestic violence order. Those differences can impact how the order is enforced. And what I mean by that is you can call the police if your DVO has been violated. And that being said, if the person isn't there when the police arrive, they're probably not going to go out and arrest them. But you could go to the courthouse and file on your own a motion to show cause or a forthwith order of arrest. A forthwith order of arrest is generally more appropriate if there's some sort of immediate threat to you that's been issued. A show cause order, maybe you've got an order for no contact, but the person has sent you a text or a friend request on Facebook or on Instagram. So keep that in mind. And that's just one basic example of a civil restraining order versus a domestic violence order difference. So.
Michelle, we had a question about whether we help with child custody or visitation cases.
Yes, we do assist with those. That being said, there are certain things we have to consider when we figure out which cases we're taking on, because we want to accomplish two things, right? We want to help as many people as we can, and we want to make the best use of our resources that we can. So if you're a victim of domestic violence or sexual assault or stalking, you can reach out to me through that side door intake process. You can contact Bethany House and they can get you in touch with me, or Adonta Sexual Assault Resource Center, or even our central intake, and they do a great job and they will get you where you need to be with respect to that. Now, there may be sometimes we don't accept a case for extended services, and that may be the case if there's already some sort of custody order in place. And that could be through a juvenile action, which is separate and distinct from a divorce or a custody case. There could be orders in place because you were already divorced, and we've got certain limitations on what we can accept with post-decree matters. So that issue, if it's post-decree, is going to be, are you getting any visitation at all, essentially? Are you being withheld or denied? And we take those cases to our directing attorney who considers it, and sometimes even further up to figure out, is this a case where we can really help someone and make a difference? In general, when someone needs some custody orders, we evaluate that very case by case. What are the facts that are going on, and make a determination as to if you're going to get just advice or if we're accepting it for something extended. But if you need assistance with custody or visitation, absolutely reach out to us, and at the least you will probably end up with at least some advice. That's if there isn't a conflict. We do have to check for that. But again, we try to help everyone we can. So from my perspective, I think most folks who contact us for that sort of help end up getting something, at least, as much as we can. So yes, we do. And we are, again, hosting a divorce self-help clinic. So if the custody or visitation order happens to be associated with a divorce, having a clinic for those who need divorces, and I believe also have children, and that's on July 16th, and you must register in advance by central intake. And that is a situation where you all have some sort of agreement, essentially, and not everyone can do that, right? Especially victims of domestic violence or sexual assault. Often it can be very difficult to get their abuser to agree to something and may potentially endanger that person. So I caution anyone who that criteria applies to in terms of thinking about an agreement and going forward with something like that. Okay, so in terms of, it looks like we're getting a little bit more information about this case. That may be something best handled within the contents of a private phone call, perhaps. So I would encourage you, reach out to central intake, and they will get you where you need to go. Because it sounds like we need to give some very, very specific advice in terms of your specific situation, Jason. So I wouldn't want to give someone general advice and find out there's more facts, stuff we didn't know, and it just didn't work out that way. So. But also, thank you all for your questions. Keep them coming. That's great.
And I can add another question, Michelle, that I think might be helpful for people to know. What would someone do if they don't speak English, if they speak in a language other than English, and they need to appear in court?
So there's a couple things with that. If your language issue is because you are deaf or you need an interpreter, you can reach out. There are different lines of access, language lines, and they've got something similar set up for folks who are deaf. I've done email intakes before with people who are deaf, so I try to keep that accessible. I do know some limited sign language, not to the point where I will be, interpreting in court or anything, but I can at least, spell my name, do some basic communication that way. And what I do for my clients is generally I reach out to the court myself and say, hey, we've got this person who has an accessibility issue. We need to make sure that we've got an interpreter on hand. And we also do that for speakers of languages other than English. Like, for instance, if you speak Spanish, we would absolutely do that as well. And AppalReD uses the language line for an interpreter when we do a call and we're trying to learn the different facts and things about the case. So there's definitely options there. And as far as when you're in court, they are required to provide you with that interpreter. So don't be worried about you getting charged for it. That's not it. You are entitled to have that interpreter there. So definitely keep that in mind.
And Jimmy, I had a question for you. So that I got here. So what will happen if someone just hasn't been able to pay their rent recently? Like, what's the process? What should they expect? What remedies might they have?
Well, the moratorium on evictions, it's not going to last forever, and it's looking like it might end about July 1st. And so after that, your landlord will be able to seek an eviction in a normal way. Like I said earlier, they can't do things like shutting off your utilities or locking you out to kick you out, but they'll be able to pursue an eviction in a normal way. And if you haven't been paying rent, and because of that, it can be helpful if you can get your landlord to agree to some kind of repayment plan. If you do that, you should just try to make it clear between you and your landlord that this repayment plan includes an agreement from your landlord not to evict you as long as you're making the payments under the repayment plan in addition to your normal rent payments. And if your landlord is willing to agree to that, that can keep you from getting evicted. But otherwise, your landlord is going to be able to evict you as soon as the courts are open to taking evictions based on non-payment of rent again. I think right now they're already accepting evictions based on reasons other than non-payment of rent. It's just necessary it potentially creates a situation where it's necessary for the judge and the eviction court to be kind of sensitive to whether or not the real reason is non-payment of rent, but the landlord is just kind of alleging this other reason. But if you're not paying your rent, you should try to work with your landlord. It's not the same as the situation with mortgage lenders where they kind of have to, where they have these federal insurance requirements that kind of tie their hands a bit in terms of working with you. They don't necessarily have to, but some landlords might anyway, because they might figure the better way for them to get their money might be to work with you. So it's worth trying to talk to them to see what they'll be willing to do.
Great. Thank you, Jimmy. It looks like we also got another question coming in from the public here from Stephanie. And so what you're asking about there is something else that I handle here at the office, and all of our attorneys can help with, which is a will or a power of attorney. So you're talking about making sure your property gets to the person you want it to go to if something was to happen to you. That would be your final will there. And we do help with those. We can provide those free of cost to people that qualify for our services. So again, call our central intake line with that. And if you qualify, that's something we can help with. If you don't qualify for our services, that's something that most attorneys can help you with. You can find some stuff online, but I would advise you to go through an attorney to make sure it gets done the way exactly how you want it to be done. And you can designate how every single possession you own goes to somebody if you want to. You can be as specific or general with those if you want. And definitely with the way the laws are written right now, if you're not married, you want to have a will to make sure that gets to where it needs to go. As far as for her to be able to make decisions for you, that's what we call a power of attorney. And you could designate her as we call it an attorney in fact. But yeah, you can give someone else the power to make financial decisions, medical decisions, decisions regarding your property and all that. You can designate someone with the power to do that, and that's also something we help with. If you were to get in touch with us and it was something we could help with, and you're qualified for our services, I mean, the process is that I would usually go through with you is we go through what property you own, who you want that to go to, what's in your estate. That's how we would do the will. Have it written in a way to where the property gets to the people you want it to, and it doesn't get to the people you don't want it to if there's that situation going on. And then on the power of attorney, we would talk through with you what all the powers that you would be granting someone else mean, when that would go into effect, how that would affect you, and how it would be able to help you out. And we'd also go over all that with the person you wanted to designate your power of attorney if you'd like us to. So those are two things we help with, and the best way for you to accomplish the things you were asking about that question is to have a will made and then a power of attorney done. And if you've had one of those done before that leaves the stuff to somebody else and you're wanting to change that, you need to have a new one done that will revoke the old ones. So I hope that answers your question. Thank you for it.
We have another one. How does the recent SCOTUS, so that's going to be the Supreme Court decision on LGBT employment discrimination, affect us here in Kentucky? Any volunteers to take that one before I start talking?
I can take that one. And then you can probably supplement what I'm going to say, and probably would say something similar. But what I can say about that one is immediately following that decision, it is illegal for your employer to discriminate against you because of your sexuality or your gender identity. That is the immediate direct effect of the decision is called Bostock v. Clayton County. That's the immediate direct effect of Bostock v. Clayton County, is that the Supreme Court decided it's illegal under the Civil Rights Act of 1964. it is illegal sex discrimination for your employer to discriminate against you because of your sexuality or your gender identity. In addition to the immediate direct effect of it, there are also probably going to be some kind of knock-on effects in terms of how some other laws are interpreted. I think based on Bostock v. Clayton County, it would be very difficult for courts to interpret the Fair Housing Act, which also includes provisions against sex discrimination, and various state laws also include protections against sex discrimination. Title IX includes protections in an education context. Based on Bostock v. Clayton County, I think it would be very hard for courts to interpret those as not including, as not making it illegal for someone to discriminate against you on the basis of your sexuality or your gender identity. Now, what I should say is that Supreme Court case, it doesn't necessarily control these other decisions. It's just going to be looked at as potentially influencing the decisions, as being because one of the reasons why I think it's going to potentially have a significant influence, even in the case of, for example, there are certain state laws that also protect against discrimination based on sex or gender, and typically those, in most states, those haven't been expanded to include protections for sexuality or gender identity. But the reasoning in Bostock v. Clayton County is so strong and it's so compelling that it's going to give you a good argument in just about any state that has any protections from discrimination based on sex or gender. The reasoning, just so that you're aware of it, is that if someone is discriminating against you because you're gay or lesbian or because you're transgender, they are discriminating against you on the basis of sex. And you can make that clear with kind of an example. If your employer fires you because, for example, you're a man and your employer fires you because they see you in a relationship with another man, a woman in that same situation, in a relationship with that same man, would not have been fired if your employer is in fact firing you because of your sexual orientation. And that sort of rationale extends to just about anything in the area of discrimination based on sexual orientation or gender identity. Do you want to add anything to that, Michelle?
I do. So in terms of at-will employment, I think many of us, or in my circle, and I admit my circle is a privileged circle in the sense that most of us have gone to law school, but Kentucky is an at-will employment state. So that means your employer can look at you and say, you're fired. They don't have to give you a reason. If they don't have to give you a reason, it can be very difficult to prove that it was because of your sexuality or your gender identity, or maybe you've chosen to come out now and you're starting to feel more protected within this atmosphere where we've gone from having very few county ordinances and effect fairness ordinances to having decisions like this from the Supreme Court. So with that being said, what I really stress is document everything as much as you can. Text messages are great. Emails are beautiful. Social media, this is great in family law. Okay, it's great and horrible in family law, but if you can find your employer's social media and they post some sort of rant about you and your sexuality and your gender identity, and then you're fired, I mean, to me, that looks like it might be closer to the smoking gun evidence you'll need to prove there's been discrimination in terms of filing an EEOC complaint and going forward with that. I would also encourage and remind everyone that Kentucky, in terms of recording conversations, it's a one-party consent state. So if you're party to that conversation and you've got your cell phone in your hand, and most of us do, pop that record button. Hopefully it's good quality. That's the only thing I'll stress to you, because sometimes we hear things and you can't tell who's saying what, and that can make it very difficult. But just some things to keep in mind. So just because we're at will employment doesn't mean a claim of discrimination is impossible. What it does mean is we're going to have lots of documentation about that in order to refer you and say, I think, the EEOC will be really interested in something like this.
And I'll add to the issue of being at will and other things like that. Like a prospective landlord doesn't have to give you a reason for not being willing to rent to you. Things like that. What I'll add to that is that before you talk to an attorney about a discrimination case, if based on your interactions with this person, what your intuition is that they're discriminating against you, and if you really believe that, it's still probably a good idea to talk to an attorney about it, because different of these discrimination laws, they actually can have presumptions that can work in your favor. Like in a landlord-tenant contact, there can be a presumption that your landlord is discriminating against you. If you're a member of protected class, the landlord knew you were a member of protected class, they rejected your application, and then your apartment continued to be vacant. And the reason for that, there's just kind of a common sense reason for that presumption. It's kind of weird for your landlord to continue to let the apartment be vacant when they've got someone who's got a good application in front of them. Now, what presumptions do is that your landlord's going to have to explain why they rejected you. I mean, obviously, that explanation will have to include something other than discrimination. But if they can't do that, it's pretty suspicious that they rejected someone and then just let the apartment vacant. And other laws have, and there are other situations that can also create presumptions that can work in your favor in a discrimination context. So, don't necessarily just assume that because you don't have exactly the right thing recorded, or what Michelle calls smoking gun evidence, that you're not going to have any case for discrimination. I think it would be a good idea to call a discrimination attorney about it, or to report it to the EEOC or the Fair Housing Commission, something like that, and there might be something that can be done about it. So.
Yeah. And just to add just a couple quick things onto that is when they're talking about document, that's for about every area that you might need to go talk to a lawyer about. I know, especially with education law, if there was one thing I think a lot of attorneys would say, if you ask them what's something you wish a client would do before they came to you the first time, and that's it, to document what's gone on. So like in the education sense, tying it back to that, like keep a log of like, I asked them for these services on this date and like nothing was done. I went to the school and met with the principal on this date, and this is what I asked for, and this is what their response was. Keep emails, text messages, all that stuff. That's all extremely helpful. Another thing I wanted to add though is just a statistic, but going back to that the Supreme Court case is something that some of our AppalReD staff had found and put up that I thought was really neat was there were some county ordinances that went as far as to protect workers from discrimination based on gender identity and sexuality before, but they only covered about 30% of our state, and then now that Supreme Court decision has become law, 100% of our state is covered. So I do think it's important to appreciate that progress. It's way too late, but I think we should appreciate that. I think that's pretty cool.
Yeah,
we had a question from a Terry Schoen about needing help with a divorce or a QDR. Because it's kind of outside of my area of law, I'm not even sure what a QDRO is.
We call it
yeah. Sorry, what?
We call it a quadro.
Quadro. Okay.
Yeah, and I know that because we actually had a training on it. I know that there was an attorney who presented on it, I believe, at a CLE. So we attorneys have to do continuing legal education every year. It's great. I feel it's great anyway. But and AppalReD gives us lots and lots and lots of training. So very, very good, very valuable information there. But anyway, I know that this attorney in Lexington specializes in quadros. I believe she also brought up railroad retirement benefits at one point. It's been a couple of years ago. I think it was back in 2017. but I am sure that the folks at Legal Aid of the Bluegrass know who I'm talking about. They were present at the same training. And I remember that attorney saying specifically, if you need help with a quadro and you are an attorney, call me before it's done rather than after, because that is complicated. It is complicated, it is hard. I know that we've done some in the office. I personally have not done one yet. First time for everything. But yes, Legal Aid of the Bluegrass will be who you want to reach out to in terms of divorce, quadros. I'm unfamiliar with the last, the TIAA CREF. I'm gonna have to look that up. So learn something new every day. That's the fun part of being an attorney. Fun and maybe a little awkward.
Like a teacher's retirement fund or something?
I would assume something like that, yeah. So I hope that answers your question. In terms of we don't refer specifically to private attorneys. We do have a wonderful VLAC program, Volunteer Lawyers Association of Kentucky. Did I get that right? Anyway, Mary Going is kind of at the head of that, and we try to use private attorneys who are willing to say, hey, we'll help you out. You guys do good work. Let's support you as much as we can. And we're very grateful for that. We've had help from lots of folks. We've had help from folks with bankruptcies. There is a lot of work to go around. I saw something during the course of the pandemic, and it was a meme about what we need during a pandemic. And it was how, obviously we need emergency workers, we need police, we need medical professionals. And someone made a comment, we don't need lawyers. You don't need some lawyers, but some attorneys are absolutely, we are in that crutch there. We're here to help you with eviction. We're not here to come after your money. We are here to fight for the rights of the most vulnerable. And I absolutely believe we do that every day. And if we can't figure it out, we will reach out and use all of our resources until we get to that point. And then we'll just be honest and say, I don't know, but let me try to find someone who can help you. So I never like to just turn someone away and say, I can't tell you anything. So, all right. Well, Jimmy, on that strain of discrimination, so I think I've got a question for you. What can someone do if there's discrimination by their landlord or their mortgage lender?
So right now, like I said, it's likely to be the case that the same anti-discrimination laws that apply to discrimination based on race and gender are going to be extended to discrimination based on sexual orientation or gender identity, but it's not guaranteed. There has been a court ruling on those. But again, as we've been saying, and I didn't necessarily mean to de-emphasize this earlier when I was talking, but it is always very, very helpful to have things like this reported, because having a smoking gun evidence is going to put you in a much stronger situation than not having it. So you're going to want to, if you're being discriminated based on any reason at all in housing, you're going to want to call the Department of Housing and Urban Development about it, and you're going to want to look to get an attorney to possibly help you with a discrimination claim against the prospective landlord or lender and there can also, of course, be cases of discrimination where the person's already your landlord, but they're treating you differently than the way they treat other tenants, and it's because of your race or your gender or your sexuality. And those are also things that we can help with. Those things, like I said, they're likely, at least as far as gender identity and sexual orientation, they're pretty likely at this point to be held to be illegal under Fair Housing Act and under state laws as well. And for the other things, it's already well established that it's illegal to discriminate in housing on the basis of race or gender.
On that note, before we go too much further, I know we haven't had a question about it yet, but I just want to address real quick, because we are speaking particularly to the LGBTQ community and focusing on them. An example of someone might be wondering, what do I do if my partner has outed me? What can I do if my partner has outed me? All right. And it wasn't something you wanted. It wasn't something you were ready for whatever reason. So if someone comes to me with that information, and that's the first thing they say to me, I'm going to ask what else has happened, because I hear that, and with my training and with my work with Bethany House Abuse Shelter, I know that that can be a part of domestic violence. So I'm going to ask you some questions about if your partner has broken things around you, if they physically hit you. Sometimes I get questions from clients and they say, well, they've only verbally abused me, or mental abuse. And the more we talk about it, I realize this person's life has been threatened. And that is absolutely getting into that domestic violence territory. We're right there, right on the verge of physical, okay? So if someone holds out a weapon and they're just talking, but they bring out a weapon every time you argue, I know we're talking about domestic violence, and that's where I should be pointing you. So with that in mind, you can file a protective order. Make sure you list all the things. This is one of those things where having a court advocate like the ones at Bethany House or a Donta Sexual Assault Resource Center are absolutely crucial. We're talking to us, because if a judge reads just that your partner has outed you, they may not comprehend all of what's going on, okay? You'll still get a hearing even if your initial emergency protective order is denied, and you'll get an opportunity to present evidence. In the meantime, you wouldn't have anything protecting you. And I don't like that. No one likes that. So I just want to make sure that you guys know that. There are other different options. We may be able to help you reach out to maybe the county attorney's office if there's some harassment going on, some stalking going on, help you make those connections with law enforcement. We realize maybe not everyone is comfortable in that space, but that is our space. We are in the space of law. And we know sometimes we can be very important in bridging that gap, and that's what we want to do for everyone. So.
And Jake, I had a couple of questions for you that I think might help clarify things for some people.
Yeah.
How long exactly does it take to get a criminal record expunged, and about how much does it cost?
Yeah, well, for a criminal record expungement, it depends on the court you're in. It's different with everyone, but just kind of a brief rundown of the processes. The first thing that you would usually do in that process is you have to request a certificate of eligibility from the state. There is a $40 fee with that, but if you contact us first, there are ways to get that paid for. So one of the ways is depending on the health insurance provider you have. Some of the Medicaid providers in the state, I know WellCare will cover the cost of an expungement certificate, as well as Anthem will cover that. And actually, if you have Anthem, you can just go through us and we can have that paid for you. Another way to get that paid for is to go through the Goodwill Clinic that I referred earlier. I think there's probably information on our page with. From the time you get your certificate and we get the petitions filed for you, it can take anywhere. On a misdemeanor, it's usually just a few weeks to a couple of months. On a felony, it can take up to 6 months. It usually never goes beyond that. There's some deadlines in there for the judge to rule on it and the prosecution to respond. As far as cost goes, the actual cost, as far as filing fees and expungement fees, it's $100 for a misdemeanor. It's $300 for a felony, with $50 of that to be paid up front, and a $250 fee when the expungement is granted. But I don't want that to scare anybody away, because there are ways we can ask for the court to waive those fees. There's ways we can try to find funding to help pay for that. Even if none of that works out, then there's payment plans they can put you on. I don't want the money to be the reason that anybody doesn't do that if they're otherwise eligible or curious about having that done. So please contact us. But you're looking at a time frame from the time you talk to me to when you have the charge off your record. I mean, it's usually no more than 6 months, but it could be up to that depending on the type of charge and what county you're in.
And then what if someone doesn't know what's on their criminal record?
Yeah, so something you can do there is you can check with the county you were charged in, ask for a copy of the file from whenever you pled guilty. But to be honest, if it's something where you think the charges were in our coverage area, if you get in touch with us, we can usually look up the record to see, at least get an idea. It may not be an official record, like the certificate is, but we can get an idea of whether it'd be a good idea for you to go ahead and request a certificate of eligibility or not, whether it'd be worth it for you to go ahead and spend that $40 if you have to. But really the main way to know is the certificate of eligibility. But while I'm talking about those, if you were to get one of those, they're not always right. So just because it says that a charge isn't eligible doesn't mean you shouldn't follow back up with us. We may be able to get around that or show that they were wrong on their certificate and still get the expungement for you.
I got one more for you, Jake.
Okay.
What would someone do if they think that their child needs accommodations and no one will listen to them?
Okay, that is when it's a good time, again, to reach out to us or another attorney that you're comfortable with. Because, like I said, your child is entitled to a free, appropriate public education. Nothing should be getting in the way of that, whether it's a denial of accommodations for a learning disability, an emotional behavioral disability that maybe caused them to act out in the classroom and they need some accommodations to help that out, whether it's discrimination based on sexuality or gender identity that's causing them to be so uncomfortable at school that they're not able to get that education they deserve, whether it's bullying like we talked about to the point where they're being denied the education and if no one's listening to you and trying to help you out at all. That's when you should reach out to us. And going back to the documenting, you want to document all the attempts you have made at trying to get something done before, because that helps us out a lot. If I go into the school and say, hey, why hasn't this been done? And they say, well, this is the first we've heard about it, and I don't have any proof otherwise, it still can get things moving in the right direction, but it may not be as effective as if I can go in there and say, look, I know that so-and-so's mom, contacted you, this day, and this day, and there's still nothing been done about it. It's easier if we can go in with something like that or have messages to show, emails to show, those types of things. But that's when you should definitely reach out to us. We're happy to, even if it's not something where a lawsuit is appropriate or filing some kind of formal complaint like that. Sometimes, we can just give you the advice, or we can write a letter to the school on your behalf, go to a meeting with you, try to explain your position a little better and advocate for you and your child. Again, it's fact specific on what types of cases we can take, but if you're having those types of issues, please reach out to us and we'd be happy to talk about it with you. If we can't help, we can try to point you in the right direction. And another thing to add in, I think hopefully this has gotten across. If you don't know this, but just looking at the last message that our Facebook page sent out is any consultation with us at all, and that includes just like the shooting us an email, is confidential. There is what's called attorney-client confidentiality, and even if it doesn't get to the point where you consider us your attorney or you our client, anything where you're reaching out to us is completely confidential, and so know that. And so we do hope that fear of being outed or being discovered or being put on blast or something like that, don't have that fear if you're reaching out to us.
And I want to add to that, because I am someone who has a teen in my home. So if you are a teenager and maybe the person who is abusing you is in your house, you are the client. If you reach out to us, you are the client. If you are a 15-year-old who is being put through things I cannot imagine, you can reach out to us. We will get in touch with you. We will get you the help that you need, okay? You are safe with us. We are not going to call your parents on you if those are the people who are hurting you, or whoever it may be. And I say that in relation especially to kids who have been through the foster system, because I understand that you are very much disproportionately impacted by abuse and by some of the less savory parts of life in Appalachia sometimes. Sometimes we like to keep things in the family, but you are important, you are worthy, and we are here for you. You are our people, all right?
Okay, is that it?
I think so, and thank you to everyone behind the scenes making this happen. We have a really incredible team at AppalReD. I can't say enough about them, from the secretaries to folks we've got with communication and IT. I'm very proud to work here.
Yes, and thank you all to everyone who watched and to the people who asked questions, because, you know, if you're asking the question, there was probably other people on here today that had the same question, or know somebody that information will be helpful to. So we really appreciate people participating in this and asking those questions.
Yeah, absolutely.
All right, bye.